imagine walking into a courtroom, right? Your home and your business are totally on the line. But then you look up at the bench and realize the judge deciding your fate, well, they just stopped working for the exact bank that's trying to foreclose on you.
Yeah, I mean, that immediately shatters the whole foundational assumption of any legal proceeding. The idea that the person wielding the gavel is actually neutral.
Exactly. And that profound paradox is exactly what we are exploring today. So welcome to the show, Jacob. We're speaking directly to you today because the source material we're analyzing is intensely personal.
Right. It's a legal document titled Application to Assume Original Jurisdiction and Petition for Extraordinary Relief. And you filed this pro se, meaning you're acting as your own attorney, right, in the Supreme Court of the state of Oklahoma.
Yeah, and our mission here is to sort of synthesize the dense mechanics of your legal arguments. That way you can review the structure of your case objectively, maybe as prep for your upcoming legal maneuvering. And Jacob, a quick reminder before we really dive in. This isn't a typical podcast episode or anything like that. It's a deep dive exploration into the source material you provided, tailored specifically for you.
Yeah, and to set the scope here, your petition outlines a truly harrowing cascade of events. I mean, we're talking about the loss of a homestead, a plumbing business, and child custody across 3 separate proceedings in Pontotoc County.
Which is just a massive amount to deal with.
It is. But the core architecture of your legal argument, it actually hinges on a single foundational defect. It's a severe alleged conflict of interest involving the presiding judge, Associate District Judge Lori L. Jackson.
Okay, let's unpack this. Because the details you outline in the petition regarding this conflict are just staggering.
Yeah, they really are.
Because before taking the bench, Judge Jackson actually served as counsel of record for Vision Bank. And that is the very entity foreclosing on your property.
Right. And you note that she then transferred that client to the firm that subsequently prosecuted the foreclosure before her.
Which is crazy enough on its own. But the conflict also extends to a related case regarding your business equipment, right?
Yes, exactly.
Because her spouse is an officer at Oklahoma Heritage Bank, which is the plaintiff in that second action.
Right. And what's fascinating here is you're using these layered conflicts to argue something much heavier than just simple bias.
Oh, totally. It's like having a referee in a championship game who, just quit coaching one of the teams. And on top of that, their spouse is actively betting on the game. How does a legal proceeding even commence with that dynamic?
Well, it shouldn't. And you are arguing she lacked the lawful power to hear the case at all. By citing major Supreme Court precedent, your petition builds the case that a judge presiding over a matter where they previously served as an advocate is a structural error requiring vacatur.
Meaning the rulings aren't just unfair, they're legally void.
Exactly. You're telling the High Court these rulings shouldn't even exist because the tribunal itself was invalid from the very moment it convened.
So, if a court fundamentally lacks the authority to hear a case, that explains how the procedural safeguards can just completely break down later on.
Oh, absolutely. And Jacob, in your petition, you juxtapose 2 timelines to really prove this breakdown. You point out that on December 6, 2018...
The day of the graveside service, right?
Yes. The exact day you were burying your infant daughter and the day you were actually served, the court was simultaneously entering a default judgment without a hearing.
Wait, the exact same day? Man, that is just devastating.
It's incredibly heavy. And you're using this staggering timeline to prove the orders are void on the face of the record.
And you reinforce that argument by pointing to the bank's own paperwork, right?
Yes, because the mortgage explicitly required a 35-day opportunity to cure the default. But your petition shows the bank admitted to acceleration.
Which is what, exactly?
It's basically a legal term for demanding the entire loan balance immediately. And they did that without giving you that required notice or demand.
I'm stuck on something here, though. If their own contract, the one attached to the lawsuit, physically says you get 35 days, but they filed for a default judgment on day 1.
Right. It seems impossible.
Yeah. How does a judge legally sign off on that? Doesn't the physical contract attached to the lawsuit override whatever the bank's lawyer claims in the motion?
It does. And that is the exact mechanism of Jacob's argument. When a court's own documentation proves that the legal prerequisites for a suit haven't been met, well, the court simply doesn't have the authority to grant a default judgment.
Wow. Did the bank use that same accelerated playbook when they came after the plumbing business?
They did. They use a legal mechanism called replevin.
Remind me, that's like a fast-track process for seizing things, right?
Yeah, exactly. It's used by creditors to physically seize property really quickly. Oklahoma Heritage Bank filed to seize $60,000 worth of your plumbing equipment.
And the court clerk issued an order for delivery the exact same day, like before you were even served.
Yes. But the crucial error you point out involves the bond they posted. It was only $40,000.
Wait, why does that specific dollar amount matter so much to the legal argument?
Because the law requires a bond in a replevin case to be double the value of the property. So for $60,000 of equipment, it should have been $120,000.
Ah, got it. So that law exists specifically to protect a defendant from total financial ruin if the seizure turns out to be wrongful.
Precisely. So by granting the order on a facially deficient $40,000 bond, the court bypassed a mandatory critical protection.
So when a court operates without those procedural safeguards, the breakdown doesn't just impact physical assets like trucks or a house. In your petition, Jacob, you show how this exact same disregard bled right into your family rights.
Yeah, that's perhaps the deepest cut here. You previously had joint custody of your two sons.
Right, which was established back in early 2018.
Right, and while you were incarcerated, the mother filed to modify that custody. Now, the law requires personal delivery of notices to an imprisoned person.
But your petition outlines that notices were sent to addresses where you didn't even live.
Exactly. Or they were sent to a jail administrator in a completely different county.
So legally, you never even got the memo.
Never. Yet Judge Jackson entered an order of modification, giving the mother sole custody and leaving you with zero visitation.
Unbelievable.
And the stated reason. She cited that you, quote, appears not, end quote, as a sanction.
Wait, seriously? It's essentially like holding a trial in a soundproof room where the defendant isn't even legally allowed in the building, and then permanently penalizing him for not speaking up.
That's a really great analogy, and it's exactly why this elevates from a procedural error to a full-blown constitutional one.
Because of the fundamental rights involved.
Yes. Your petition argues, based on established Supreme Court precedent, that a parent's interest in the care of their children is a fundamental liberty interest. Taking that away without a meaningful opportunity to be heard is a clear violation of due process.
Normally, if a defendant is hit with a bad ruling, you just file a standard appeal, right? That's the normal process.
Right, usually.
But here's where it gets really interesting. Your petition explicitly argues there is no adequate remedy at law.
Because normal appeals require a litigant who is at liberty and actually received proper notice.
Exactly. And a standard motion to vacate these orders would normally go back to the district court, meaning it would land right back on the desk of Judge Jackson, the very person you named as a disqualified respondent.
Yeah, it's wild. To fix a biased ruling, the standard system literally forces you to appeal to the allegedly biased judge.
It's an absolute catch-22. You basically have no choice but to try and leapfrog the entire lower court system.
And if we connect this to the bigger picture, that's exactly the legal strategy behind asking for original jurisdiction. You are asking the state Supreme Court to issue writs of prohibition and mandamus.
Which is basically telling the high court to step in directly and force an action.
Yes. You're asking them to declare the orders void, restore record title to the homestead, return the equipment, restore joint custody, and remand the entire case to a completely different, unconflicted judge.
Stepping back, Jacob, your strategy here is just remarkably cohesive.
It really is.
You've taken this sprawling loss of property, business, and family, and you've anchored all of it to one devastating root argument, which is a fundamental lack of judicial authority. Seeing these dense legal arguments distilled into this overarching narrative structure is really crucial for communicating your case clearly in whatever arena comes next.
And speaking of that next arena, your text mentions briefly that you're pursuing damages in a separate pending federal action.
Oh, right.
So here is a final, forward-looking thought to consider. If the Oklahoma Supreme Court agrees to assume original jurisdiction and officially declares these state court orders void, how will that state-level invalidation instantly act as a catalyst or even a weapon in your ongoing federal lawsuit for damages?
Man, that is the big question. Because if the high court agrees the foundation was invalid, well, everything built on top of it just has to come down. Jacob, thank you so much for bringing such compelling material to the table. We wish you the best. Until next time.